Okay, good morning, everyone. Welcome to our information session on the New York State Open Meetings Law. Again, my name is Kristen O'Neill. I'm with the New York State Committee on Open Government. I start out by giving everybody a quick peek at the Committee on Open Government's website. I'm going to open chat just in case. Just so you know, I think when I do this, sometimes parts of the screen are blocked, little areas where I have a part of WebEx open. It's going to block part of the screen on your end, so I apologize for that, but unfortunately I'm not enough of a tech wizard to know how to make that not happen. But I just want to try to pull things out of the way as much as possible, but still give you guys, still be able to see the chat function and also show you what the Committee on Open Government's website looks like for those of you that may not be as familiar. Here on our website is opengovernment.ny.gov. From our web page, you should see links to, someone is asking if they can, should I be hearing someone? I'm hoping that everyone can hear me. Can someone send me a note letting me know that they can hear me? Okay, I'm getting lots of I can and a few I can't. So if it's an I can't, then there's probably a good chance that the problem might be on your end. So we're going to move forward with that. I appreciate the people that have sent me notes. That's why I try to keep the chat open, because sometimes things like that happen. So from our Committee on Open Government website, you can see that there's lots of information available. From the top of the screen, there are a couple of different menu options. One is relates to information about the Freedom of Information Law. You can see the text of the statute, the regulations, links to our advisory opinions, links to our litigation case law summaries. We have model rules for agencies that are subject to FOIL. We have information about the Personal Privacy Protection Law, which governs access to records and how state agencies must keep private certain records that they maintain about individuals, but that only applies to state agencies, so we don't deal with it as often when you're dealing with municipalities. Same goes for open meetings law. We have the law, we have the advisory opinions, case law summaries. Here, if you're looking for perhaps in our next meeting of the Committee on Open Government that's where you're going to find information here. Anything new that has happened recently, we'll have it under our news. And of course, we have a contact us page, which has our phone number, email address, and mailing address. On our home page, if you're looking for maybe an update on something that's particularly sensitive, for example, the thing that has been most frequently that people are looking for updates are on where are we with the open meetings law in terms of remote access. And so people come to our website to look to see where we are currently in terms of being able to host remote meetings. And we always try to keep that information up to date on our website. So you'll see here a couple days ago, the governor extended the declared state of emergency so that it is currently good through March 16th, 2022, that the declared disaster emergency is in effect currently through March 16th, 2022. And the ability to hold remote meetings expires when the declared disaster emergency expires. So that's the date that we're looking at. As long as the state of emergency is in effect, the ability to hold remote meetings will be in effect. We also have some other interesting information, any updates. We've had quite a few updates to the open meetings law in the past 6 months or so. We've got that information here. And of course, I put the information about this program on the top of the screen. As you scroll down, you will see sections, these green boxes that give you some guidance about here's some language about how to make a FOIL request. Here's some language, guidance about how to file an appeal, a denial. here's an overview of the time limits that an agency needs to comply with for responding to a FOIL request. I'm still getting notices, people saying that they can't hear anything. Unfortunately, I think the problem must be on your end, because if some people can hear me, then it means it's working on my end. So if you're having difficulty hearing, there's really not a whole lot I can do for you, because I am the staff here. I can't provide tech support. If you are looking for recordings of meetings of the Committee on Open Government, those are available here. And this is important. If you go to this page here, you will see at the end of this program, I will request that a recording of this program be posted on our YouTube page, which is being slow to pull up, but I'm not going to worry about it too much. If you click on this link here, you will see old recordings of any programs that I've done in the past. And also you will see copies of the materials that we're going to go over today. And I just updated that. I just asked our web staff to update this today. So you'll see the exact PDF, excuse me, the exact PowerPoint that I'm going to go over today is available right on our website. So for anyone that's interested in going over this program later, you just go right to our website and that information is there for you. Okay, so I just wanted to give you a quick overview of our website, because there's a lot of helpful information there. I'm going to close out here, and now I'm going to go back to, I'm going to stop sharing. Stop sharing, yes. I'm going to go to share my PowerPoint, open it up, and here we are. Excellent. So the New York State Open Meetings Law, what we're going to focus on, we're going to do a full overview of the statute, but we will focus a bit on the ability to hold remote meetings and where we are currently and how it differs from the way remote meetings had to be held in the past. Well, actually, there really was no ability to hold fully remote meetings, but there was the ability to use video conferencing as a mechanism for bringing members of a public body together. We will talk about the similarities and differences there. And we will talk about what may or may not happen in the future when the declared state of emergency ends. Up on the screen right now is my contact information. That's my direct email address. So if you have a question for me specifically, you are welcome to email me. If you're just looking for, if you have a general question and it doesn't really matter who answers it, you can either, you can email our office account, which is the coog@dos.ny.gov. It's particularly helpful, for example, if you get an out-of-office message from me and you need an answer quickly, feel free to follow up directly with the rest of the office. Somebody there can help. We are a small office. We have the executive director, myself, one senior attorney, and one Excelsior fellow, which means Jake working as our Excelsior fellow, and he has passed the bar and is just waiting to be admitted. So we've got some additional staff now that we never had in the past, so that's very helpful. New York State Open Meetings Law is codified in Public Officers Law Article 7. Don't really need to worry about that too much, because we always have a copy of the Open Meetings Law and the Freedom of Information Law on our website. So instead of having to go track it down through statute books, you can just go to the Committee on Open Government's website. We try to keep an up-to-date version with any amendments on our website. When the Open Meetings Law was passed in 1976, declared legislative intent stated that it is essential that public business be performed in an open and public manner, and that citizens be fully aware of and be able to observe the performance of public officials. Citizens have the right to attend and listen to the deliberations and decisions that go into the making of public policy. I emphasize some words on this page because while the declared disaster emergency is in effect, there may be situations where you may not be able to observe all members of a public body, and there may be situations where you may not be able to attend physically in person to listen to the deliberations and decisions that go into the making of public policy. And we're going to talk about that in some detail. Chapter 1 of the Laws of 2022. On January 14th, 2022, Governor Hochul signed into law Chapter 1 of the Laws of 2022, which amended Chapter 417 of the Laws of 2021. And this statute authorizes any public body, as the term is defined by the Open Meetings Law, to meet and take such action authorized by law without permitting in-public, in-person access to the meetings, and it authorizes the meetings to be held remotely by conference call or similar service, provided that the public has the ability to view or listen to such proceedings, and that such meetings are recorded and later transcribed. So while this law is in effect, meetings can be held via teleconference. It doesn't even need to be a video conference, or there doesn't need to be any video component as long as there's an audio component. The public needs to be able to either listen to or listen and view the meeting while it's occurring. It has to be contemporaneous access. There has to be contemporaneous remote access for the public. The language of both Chapter 417, which was in effect from September through January, and Chapter 1 of the Laws of 2022, which went into effect right at the expiration of Chapter 417, substantially mirrors former Executive Order 202.1, which was issued in March of 2020. So very shortly after, when the coronavirus first became an issue in New York and in the United States, and we all started to sort of shut down and go into, keeping ourselves isolated to some extent, former Governor Cuomo issued Executive Order 202.1, which allowed meetings to be held remotely. And the language of that executive order was almost exactly the same as the statutes that followed. And so when that executive order was issued, the Committee on Open Government was getting quite a few questions, and so we issued advisory opinions. And so the advisory opinions that we issued relating to the declared disaster emergency, they still apply. They're because the language of the executive order and the language of the current statutes are so substantially similar, the advisory opinions that we offered at that time and in the months following the issuance of the executive order are still good advice. So if you're looking for advice about the ability to hold remote meetings, we do have advisory opinions on that subject. Chapter 1, which is the most recent version of the remote access statute, will expire when the states declare disaster emergency, which was issued through Governor Hochul's Executive Order 11 expires. And at this point, it is set to expire on March 16th, 2022. People start calling our office before the scheduled expiration of every disaster emergency, asking me what's going to happen. I can tell you right now, my answer to you is going to be, I don't know. Our office does not get a heads up from the governor's office as to whether these executive orders are going to be extended. We find out when everybody else finds out. We find out when a new executive order gets posted on the governor's website. So that's what I encourage you to look to, particularly if you are an agency or a public body that is subject to the Open Meetings Law. Keep an eye on the governor's website to see whether any extensions of the declared disaster emergency have been issued, because that's what's going to be the triggering factor. It's important to note that these statutes allow for remote meetings, but does not require remote meetings. If your public body feels comfortable having in-person meetings, allowing the public to attend your meetings in person, your It is perfectly accessible for that public body to go ahead and have those in-person meetings. There is no statutory obligation to have remote meetings. Pre-COVID, in order for a member to attend, a member of a public body, not a member of the public, but for a member of a public body, so a town board member, a school board member, whatever the case may be, in order for them to attend and participate in a meeting via video conferencing, the Open Meetings Law required first that the public be provided an opportunity to attend, listen, and observe at any site at which a member participates. As Chapter 1 authorizes public bodies to meet and take action without permitting in-person access to meetings, public bodies are not currently required to comply with Section 103C of the law. So in other words, if you have members of a public body that are participating from their homes, from their offices, doesn't matter where they're participating from, if the public body is having a remote access meeting in compliance with Chapter 1 of 2022, they are not required to notify the public where each member is participating from, and the public body is not required to open those secondary sites to the public. So if you are a member of a public body and you're signing onto a WebEx or a Zoom or whatever the case may be from your living room, there's no obligation for you to open your living room to the public. The public does not have a right to attend at those locations. Pre-COVID, notice of the meeting was required to include the locations of the meeting, including the locations of the members who plan to attend via video conferencing. So the notice requirement, if you had a member, for example, pre-COVID, if the town board, if most, 4 out of 5 town board members were at the town hall, of course the notice of the meeting would have to include the location of the town hall. And then perhaps your 5th member was on vacation in Florida, and that 5th member wanted to attend via video conferencing. The member was allowed to attend via video conferencing as long as the notice included the location from which that member was attending. So the public body would need to provide an address in Florida or wherever the person happened to be of where the person was participating from, and the notice had to include a statement that the public had the right to attend the meeting at any of the locations, including that secondary location in Florida, in Italy, in Cape Cod, wherever the case may be. Do I think that people were going to attend from that secondary location? No, of course they're going to go to the town hall. That's what makes sense. But this is what the law requires. Currently, under Chapter 1 of 2022, if a public body chooses to prohibit in-person attendance, the notice does not need to include the locations from which members are attending and does not need to include the statement that the public has the right to attend the meeting at any of those locations. Those secondary locations do not ever need to be open to the public as long as the public body is giving the public the right to attend remotely and is complying with all the provisions of Chapter 1. Normally, if a public body chooses to allow in-person attendance at its meetings, it must comply with 2 additional provisions of the Open Meetings Law, and one is that the public body shall make or cause to be made all reasonable efforts to ensure that meetings are held in facilities that permit barrier-free physical access to the physically handicapped as defined in Public Buildings Law. Shorthand for this is that your public body's meeting sites need to be ADA compliant. Again, right now, if you're having completely remote meetings, of course, your remote meetings don't need to be ADA compliant because there would likely not be any primary physical location. If you're having a hybrid meeting, both physical and remote, the physical location would need to be, the primary physical location would need to be ADA compliant. In my opinion, if you have maybe one of your board members is participating from home because they're quarantined or because they are immunocompromised or for whatever reason don't feel comfortable attending in person at the primary physical location, their home doesn't need to be open to the public if remote access is being made available. And even If remote access is not being made available, I don't think that location needs to be, that secondary location needs to be ADA compliant, as long as the primary location is ADA compliant. And public bodies shall make or cause to be made all reasonable efforts to ensure that meetings are held in an appropriate facility which can adequately accommodate members of the public who wish to attend the meetings. So if you are having a physical meeting, if you are having a meeting, if you put aside remote meetings, you're back to in-person, you're having in-person physical meetings, you need to make sure that your public body is having a meeting in a location that can reasonably accommodate all the members of the public who wish to attend. So for example, if you are a school board, a school district, and you have multiple locations from which you have your meetings, maybe sometimes when you know it's going to be a small meeting, you might have it in an elementary school library. If you know it's going to be a meeting that's going to draw a lot of public attention, you're going to want to have it in a larger location. Maybe you're going to want to have it in the high school auditorium or some other location that can accommodate the size of the crowd you anticipate wanting to attend. The agency, the public body, needs to make all reasonable efforts. At some point, there may not be anything more you can do. Maybe you're at the location that the large location available to you, and still not everybody can attend. But as long as you've made a reasonable effort, the public body will have complied with law. So that sort of goes over. I feel like I'm going back, starting off with a lot of detail, and then maybe going back to a little bit of more basics. But I did want to focus quite a bit on that issue relating to remote meetings, because it's of significant interest right now, and has been, of course, for the past 2 years now. What are we going to do? How do we have these remote meetings? How do these meetings differ from pre-COVID? But now we'll go back to a little bit of the basics. The Open Meetings Law governs the conduct of meetings of public bodies, and that term is defined as any entity for which a quorum is required in order to conduct public business, and which consists of 2 or more members performing a governmental function for the state, or for an agency or department of the state, or for a public corporation as defined in general construction law, or any committee or subcommittee or other similar body of the larger public body. So the questions are, have 2 or more people been given the authority to act collectively? Is a quorum necessary to conduct business? The answer to those are yes. There's a strong possibility that this entity is a public body subject to the Open Meetings Law. Committees that are made up of members of the larger public body, that are made up entirely of members of the larger public body, are also going to be considered public bodies themselves. Let's say you have a 9-member school board, and 3 of those school board members have been assigned to a particular committee, perhaps a curriculum committee or a safety committee, whatever the case may be. That 3-member committee then becomes its own public body that is required to comply with the Open Meetings Law. On the other hand, you might have entities that are considered simply advisory committees. I realize I have a typo on it says versus advisory or committees. It's just supposed to say advisory committees. I'll have to remember to correct that. It's a typographical error. When you have an entity that is made up as a mix of board members and non-board members, and that entity serves a purely advisory function and does not serve a state statutory function, like for the reference to this type of advisory committee in New York state law, they don't serve a necessary statutory function, and they are purely advisory in nature. And if they are a mix of board members and non-board members, the likelihood is that courts are not going to find that that type of advisory committee is a public body subject to the Open Meetings Law. On the other hand, if you have a committee that is made up entirely of members of the larger public body, by statute, those committees are subject to the Open Meetings Law. So I used the term quorum earlier, and the term quorum is defined in general construction law, and it states that whenever 3 or more public officers are given any power or authority, or 3 or more persons are charged with any public duty to be performed or exercised by them jointly or as a board or similar body, a majority of the whole number of such persons or officers gathered together in the presence of each other or through the use of video conferencing shall constitute a quorum. And not less than a majority of the whole number may perform and exercise such power, authority, or duty. So let's go back to that 9-member school board. A majority of the total membership, which you determine the majority of the total membership by looking at the whole number without absences or vacancies. So you have a 9-member school board. A quorum is always going to be 5, regardless of how many vacancies are on the board, regardless of how many absences from a particular meeting there may be. Quorum is always going to be determined by looking at what a majority of the whole number of the board as it should be. So, like for example, the Committee on Open Government itself is supposed to be by statute an 11-member committee. Right now, we're too short. We are missing 2 appointments to the Committee on Open Government, but it doesn't matter. Quorum of the Committee on Open Government is always going to be 6, regardless of the fact that currently we only have 9 members serving on the committee. I bolded and underlined the section about video conferencing because, again, right now, public bodies can participate together through the use of teleconferencing in addition to the use of video conferencing. If Chapter 1 of 2022 expires, you have to go back to video conferencing. Teleconferencing will not be permitted. So we already sort of talked about this. Another question that comes up sometimes in terms of quorum is whether you need to have a majority in one physical location. And the answer to that is no. Regardless of whether Chapter 1 is in effect or not, the answer to no. You could right now have a situation where you're having a fully remote meeting and every member of the board is sitting at home in their living room. So of course you don't have a quorum in any one physical location, and that is permitted right now. Even when Chapter 1 expires, and if we go back to a situation where members can only participate via video conferencing if they comply with the notice requirements and the requirements that all locations be open to the public, it will still be true that you don't need to have a quorum in one physical location. And the example here that I would give is with our 11-member Committee on Open Government, we could have 4 members in Albany, 3 members in Buffalo, and 3 members in New York City, which is how we usually held our meetings. We would have those 3 different locations, and all 3 of those locations would be noticed, and all 3 of those locations would be open to the public, but we did not need to have a quorum in one physical location because they were gathered together through the use of video conferencing. Every member, regardless of their location, could participate and vote on any particular issue. The Open Meetings Law defines a meeting as the official convening of a public body for the purpose of conducting public business, including the use of video conferencing for attendance and participation. So that's the actual definition of meeting in the Open Meetings Law. There is no authority for a public body to take action outside of a meeting. Right now, again, I know I keep repeating myself, but in addition to video conferencing, public body can participate through the use of teleconferencing as well right now. So the question is, are you having a meeting? If a public body having a meeting, is there a quorum present? And are they there to discuss public business? If the answer to those 2 questions are yes, the public body is having a meeting regardless of its intent or lack of intent to take action, or how you characterize the meeting. There's no legal distinction under the open meetings law between things like workshops, work sessions, agenda sessions, budget sessions, regular meetings, informal meetings, pre-board meetings. None of those terms have any meaning under the open meetings law. If your public body has gathered, if you have a quorum of a public body gathered together for the purpose of discussing public business, it is a meeting subject to the open meetings law. There are types of gatherings of a public body that may not trigger the requirements of the open meetings law because for the reason that they may not have gathered for the purpose of discussing public business. One are site visits. Site visits are situations where a public body have gone to to a location for the purposes of gathering information. Maybe they're going to visit a piece of property that they're considering purchasing. Maybe they're going to visit a facility that they own and the facilities manager is going to show where improvements need to be made. There are situations where from a practical perspective, it's not really possible to open that gathering to the public. So as long as the public body attends the gathering for the sole purpose of gathering information, of listening to someone presenting information, and they do not deliberate or discuss the information that they're gathering, then that type of site visit, that type of gathering would not necessarily trigger the open meetings law. And again, as I mentioned, part of this is from a practical perspective because, for example, if a public body is going to visit a piece of property that they don't own but they're thinking about purchasing, they have no legal right to open that piece of property to the public. They have no legal right to invite the public onto a piece of property that they don't own. So the public body has to self-regulate and watch themselves and make sure that they are simply going there for the purpose of gathering information and that they don't then turn to each other and start deliberating and trying to make decisions about how to move forward. Another situation that I feel comes up most frequently with school boards, although it's happened with other public bodies as well, is that a school board will say that they are going on a retreat, and they will say that it's not subject to the open meetings law. Well, that depends on what they plan to discuss at the retreat. Again, if they are gathering for the purpose of discussing public business, let's say, for example, the school board goes on retreat to discuss long-term planning for the school district, that's a meeting subject to the open meetings law. You can't just call it a retreat and exempt it from the open meetings law. If they're there for the purpose of discussing public business, then it's a meeting subject to the open meetings law. However, if they're going for team building exercises, if it's an educational seminar, if it's for a gathering where they do not intend to discuss their public business, then it may not trigger the open meetings law. It's starting to happen more frequently now as things start to get a little bit better, but certainly pre-COVID, when I would go do an educational program about either the Freedom of Information law or the open meetings law, it was not unusual in the least for a quorum of a public body to be present in the room listening to me speak. But they were not there collectively as a body to discuss public business, so that was fine. There's nothing wrong with a public body being all present together in the same room as long as they're not discussing public business. Another example of gatherings of public bodies that may not trigger the open meetings law. I'm going to go back to my school board, my 9-member school board example. We have a 9-member school board, and 3 of those members have been designated to serve on a curriculum committee. The 3-member curriculum committee then has a meeting that's subject to the open meetings law. So they notice the meeting, they open the meeting to the public, and sure enough, other members of the full board then decide that they want to attend as well. They have to be allowed to attend because the meeting's open to the public. So it is fine for example, a full school. a quorum of the full school board to be present in the room, but only the members of the committee should be permitted to act collectively, to be part of the deliberative process. Any member of the school board that is not serving on the committee has to sit in the audience and sort of zip it. They need to not engage with the committee members as if they themselves were committee members. They need to act as if they were a member of the public, because in this setting, that's what they are. They have no right to participate at that meeting. And in fact, they should not be participating at that meeting as a member of the school board, because if you have too many members of the school board at that committee member, then it's become a meeting of the school board, which you haven't told the public is going to occur. So, that's why you need to be careful about non-committee members attending a committee member. Those non-committee members need to sit in the audience and act as if they were any other member of the public. And finally, you may have social gatherings. Maybe you're going to have a holiday party. Maybe you're going to have a 4th of July barbecue for your municipality. Certainly, all the members of that public body, the governing body for that municipality, are free to attend the social gathering as long as they can refrain from going off in the corner and engaging with each other and discussing public business. So pre-COVID, the definition of meeting required physical presence or video conferencing, while Chapter 417 of 2021 and Chapter 1 of 2022 is in effect. Teleconferencing is permitted, but regardless, no matter what law is in effect, a public body cannot conduct a meeting via email. That doesn't mean that members of a public can't share information via email. One board member reads something interesting or finds some interesting information, or maybe drafts a document they would like the other members to take a look at. They are welcome to share that information via email. What they want to refrain from doing is, certainly they cannot make any decisions via email regarding any proposals that may be pending before the board. They shouldn't be voting via email. And in my opinion, they should be refraining from engaging in substantial deliberations via email, because the problem with that is if the board substantial deliberations via email and then they go to the meeting that is open to the public and they merely vote on an issue without discussing it, the public gets really annoyed. The public's like, wait a minute, there had to have been some sort of secret meeting because the board members are just voting. They're not even talking about the issues. How did they all decide that they were all in favor of this issue without even talking about it? That's why those deliberations should be occurring in public, so that the public can listen to those deliberations and see how the public body came to the decisions that it came to. Notice of a meeting. Notice of every meeting that is subject to the Open Meetings Law should include the date, time, and location, and or right now it should also include maybe instructions for virtual attendance, whether that's a live stream address or WebEx or Zoom or teleconference, telephone number, whatever the case may be. The notice should include instructions for how the public can access the meeting remotely. The notice must be given prior to every meeting to the media. This doesn't mean that the public body needs to purchase a legal notice. It just means that the media has to be notified that the meeting is going to occur. The media can then choose whether to publish that information or not publish the information. That's up to the media representative. But the media does have to be notified that the meeting is going to occur. The notice should be placed in a designated physical location, like a town bulletin board or something of that nature. And if the agency or public body has an active website, the information should be posted on that website. Notice of every meeting should be given at least 72 hours prior to a meeting that has been scheduled at least 1 week in advance. For meetings on short notice, notice must be given to the extent practicable at a reasonable time prior to the meeting. So the Open Meetings Law does allow meetings to be held with less than 72 hours notice. And the law is silent as to when that's permitted to occur, but the courts haven't been silent. the courts have weighed in and said public bodies should only be having meetings scheduled at least less than 1 week in advance and providing less than 72 hours notice if there's an actual need to do so. So maybe perhaps some sort of harm would be caused by waiting until the next regularly scheduled meeting, or some harm would be caused by providing a full 72 hours notice. So there are situations where having a meeting on short notice is perfectly acceptable, but keep that in mind that there should be an actual need to do so if a public body is going to provide less than 72 hours notice. So the next section has come up in the past 6 months, been a hot topic of discussion for the past 6 months, which I find a little bit funny because this is not a new provision of law. There's been a section of the Open Meetings Law that requires that records scheduled to be discussed during an open meeting be made available to the public since February of 2012. At this point, for 10 years, there's been a law in effect that requires public bodies to make records that they plan to discuss at an open meeting available to the public. The only thing that changed this past fall is that instead of the law saying that those records must be made available prior to or at the meeting, and what the law now says is that those records, to the extent practicable, must be made available upon request and posted online at least 24 hours before the meeting. So again, that's the only change. It used to just say prior to or at the meeting. Now it says at least 24 hours before the meeting. So we started to get a million phone calls from agents, from public bodies saying, oh my goodness, this is a new requirement that we need to comply with. And I would sort of just shake my head and say, no, not a new requirement, just a time limit that has been put into effect that didn't exist before. So my concern is that perhaps for the past 10 years, there hasn't been great compliance by public bodies with regard to this obligation. So when we talk about records scheduled to be discussed, we're talking about proposed resolutions, laws, rules, regulations, policies, or any amendments to any of those things. We're also talking about records or portions of records that are public under FOIL. And those records should be made available upon request at least 24 hours prior to the meeting. They should also be made available online at least 24 hours prior to the meeting if the agency maintains a regularly and routinely updated website and utilizes a high-speed internet connection. The law states that an agency may but is not required to spend additional monies to implement this section. Meeting minutes. All meeting minutes must include a record or summary of all motions, proposals, or resolutions, or any matter formally voted upon. In terms of executive session, a public body is only required to prepare minutes of an executive session if they vote in executive session, if they take action in executive session. If a public body merely deliberates in executive session but does not vote in executive session, no minutes of that executive session need to be prepared. Those minutes must be available within 2 weeks for an open session and 1 week for an executive session. And it does not matter whether the records have been are unapproved or whether they're still in draft form. If somebody asks for them, if a member of the public makes a Freedom of Information Law request for copies of those minutes, once they've been prepared, they must be made available to the public. On November 8th of 2021, Governor Hochul signed into law Chapter 587 of the Laws of 21, which amends the Open Meetings Law to require that agencies that maintain a website and use a high-speed internet connection, they must post their meeting minutes on their website within 2 weeks of the date of the law, within 2 dates. I back up a second. Within 2 weeks of the date of the meeting, again, another typo I'm finding, or within 1 week of an executive session. The law further states that unabridged video recordings or unabridged audio recordings or unabridged written transcripts may be deemed to be meeting minutes for the purpose of this section, just this section. That doesn't mean that if you have an unabridged video recording that you don't need to prepare meeting minutes. You still need to prepare meeting minutes. You just may not need to post those meeting minutes on your website within 2 weeks if you have posted an unabridged video, audio recording or an unabridged written transcript. But just remember, you still need, as a public body, you still need to prepare meeting minutes. Because I mean, the difference is you want to have a clear record of actions taken. In order to go back in history to try to find a record of actions taken, no one wants to have to sift through a 4-hour recording of a meeting or a 4-hour meeting transcript. They want to be able to have a simple document, such as the meeting minutes that are required by law, that reflects actions taken at the meeting. In terms of recording, any meeting of a public body that is open to the public shall be open to being photographed, broadcast, webcast, or otherwise recorded and/or transmitted by audio or video means. Any member of the public who wishes to record or photograph or broadcast must be allowed to do so. An agency can establish reasonable rules to limit disruption or interference, and we have model rules available on the Committee on Open Government's website. But as long as the member of the public is not being disruptive, is not interfering with the conduct of the meeting, they must be permitted to record or photograph the meeting. That is the open portion of the meeting, not the executive session. They have to be allowed to record the open session of the meeting. An agency or public body itself is not obligated to record its meetings unless the meeting is being held pursuant to Chapter 1 of the laws of 22. So if you're having a remote access meeting, the public body is having a remote access meeting in compliance with Chapter 1, then they are required to record and later transcribe the meeting. Now we're going to talk a little bit about executive session. An executive session is defined in Section 102.3 of the Open Meetings Law as a portion of an open meeting that is not open to the public. An executive session should never be held prior to or separate from an open meeting. There has to be a motion made and voted upon during an open meeting to enter into executive session. So even if a meeting is going to be 99% executive session, you still need to open it up at the beginning to the public, and the public body must make a motion to enter into executive session during that open portion and vote on the motion during the open portion, and then they can go into executive session for as long as they want. But again, it can't be prior to the start of the scheduled meeting, and it can't be completely separate from an open meeting. The motion to go into executive session must be specific. It must identify the area or areas that they plan to discuss, and the courts have held that the language, the motion for entering into executive session shouldn't merely parrot the statutory language. Here on the screen right now, you'll see all of the statutory reasons for that a public body is permitted to go into executive session. Again, your motion should include a reference to one of these reasons for going into executive session, but it also should be specific enough so that the public knows that you're going into executive session for a proper purpose without defeating the purpose of the executive session. For example, with regard to litigation, a public body may indicate that they are entering into executive session to discuss litigation strategy with regard to the town of, I live in the town of Bethlehem, that's why I'm picking on town of Bethlehem right now. Town of Bethlehem v. Doe, or Doe v. Town of Bethlehem. That's an example where it's specific enough to show the public, the body and the public, that you're going in for proper purpose, but you don't have to provide so much information that you're defeating the purpose of the executive session. Another example that comes up very frequently, where I see all the time in meeting minutes, in agendas, public bodies like to use the word personnel. If you read through the open meetings law, not once will you see the word personnel. There's no reference to the word personnel in the open meetings law. So I ask over and over and over again, please do not use this word in your motion to enter into executive session. It is not specific enough. It doesn't reflect to the public that the public body understands what grounds are permissible for entering into executive session. The language that's of the open meetings law that they're probably referring to states that they can go into executive session to discuss the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. And this is a good example where you don't want to just parrot the language of the statute. The motion shouldn't just say, I move to go into executive session to discuss the medical, financial, credit, or employment, blah, 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 blah. A better example would be, let's say you've received 10 resumes for a new administrative position, and the public body wants to go into executive session to discuss the qualifications of the people that have applied for that job. Say that. Say you're going into, I move to enter into executive session to discuss the employment history of applicants for position A and matters leading to the employment or appointment of an individual to serve in position A. Something of that nature. Be specific, but not so specific that you're defeating the purpose of the executive session. For example, if it's a disciplinary matter, you don't need to identify the employee that is subject of the disciplinary investigation. If it is resumes that are being reviewed, you don't need to identify the individuals that have applied for the position. You just need to identify generally that this is what we plan to discuss. And go back a little bit because I didn't necessarily talk. There are, again, these A through H reasons for going into executive session. If you don't see it on this list, and this is all included in the open meetings law, it's section 105 of the open meetings law, you will see the reasons you're allowed to go into executive session, or a public body is allowed to go into executive session. If you don't see it on this list, you can't do it. Just because a public body deems something sensitive, or they're worried about how having a public conversation is going to reflect on themselves, that's not enough. It has to be here somewhere in order for you to enter into executive session. The ones that come up most frequently are probably the litigation, the medical, financial, credit, employment history, grounds for entering, proposed acquisition, sale, or lease of real property, or sale or exchange of securities held by a public body, but only it would substantially affect the value thereof. That's another example of one that comes up. A practical example there would be is that a public body is considering purchasing a piece of property, or a municipality is considering purchasing a piece of property, and they want to discuss in executive session how much they're willing to offer for that property. That's appropriate for executive session because if they tell the whole world how much they're willing to offer, it may have other people interested in purchasing the property outbidding them, or whatever the case may be, and it could negatively impact the municipality. So that's an example. Or perhaps they're considering selling a piece of property, and this is how much we need. We absolutely don't want to consider any offers below this amount. Again, you don't want the whole world to know that because you want to try to get as much for the property as possible. Public participation. I get questions all the time from the public about how they were not permitted to speak at a meeting, and sometimes they're shocked to find out that there is no statutory right to speak, for the public to speak or participate at a meeting held in compliance with the open meetings law. There is no statutory requirement under the open meetings law for a public body to allow members of the public to speak and to participate. However, it's very common for public bodies to set aside a time during its meetings to allow for public participation. And that public body can establish reasonable rules relating to public participation to ensure that their meetings are held, or that if they are to move along at a good pace, you maybe want to establish time limits such as 3 minutes. Everyone gets 3 minutes to speak. Perhaps you have rules that indicate that your comments must be limited to business that specifically relates to that municipality, as opposed to just, I want 3 minutes to vent about the President of the United States, even though that has nothing to do with why we're here today as a public body. You can have those rules. Public bodies have to implement those rules fairly and consistently. You can't, for example, let the people that you like speak for 10 minutes and the people that annoy you only get 2 minutes. All rules should be implemented fairly and consistently. And I'll just point out here that there is a distinction between hearings and regular meetings. If it's a hearing, those hearings, how those hearings are held are governed by statutes other than the open meetings law. And there's a myriad of different statutes that govern hearings. Those statutes are all across the board: education law, general municipal law, village law, town law, city law, county law. There's a million different statutes that govern different types of hearings. And each of those statutes will dictate how the public body is required to accept public comment. So I just want to point out that distinction between hearings and meetings. And hearings may be hosted by a public body, and if that hearing is hosted by a public body, it's subject to the open meetings law in addition to creative separate statutes. But not all meetings are hearings. Most hearings are meetings, but not all meetings are hearings. Exemptions. So there are two mechanisms for meeting behind closed doors in the open meetings law. We've already discussed the first one. The first is executive session. If a public body is allowed to, if it's an executive session, if it's on the list of reasons for going into executive session, a public body may make a motion to enter into executive session during an open meeting and go behind closed doors to have the conversation. The second mechanism for meeting behind closed doors is in Section 108 of the Open Meetings Law, and that refers to exemptions. If an exemption applies, the Open Meetings Law does not. It is as if the Open Meetings Law does not exist. So Section 108 exemptions include judicial or quasi-judicial proceedings, except proceedings of the Public Service Commission and the Zoning Board of Appeals. I think some examples of this might be Board of Assessment Review, or sometimes they have quasi-judicial proceedings. If it is a quasi-judicial proceeding, and the way we determine whether it's a quasi-judicial proceeding, or in our opinion whether it constitutes a quasi-judicial proceeding, is whether it's the last step in the decision-making process before an individual has the right to challenge that decision in an Article 78 proceeding. It has to be not just something that leads to a recommendation. It would have to be a proceeding that leads to the final decision of that public body, or a final decision of that municipality or agency as a whole. That quasi-judicial proceeding can be exempt from the Open Meetings Law. Deliberations of political committees, conferences, and caucuses are exempt from the Open Meetings Law. So say, for example, you have a 5-member town board, and 3 of those members are Democrats and 2 of those members are Republicans. The 3 Democrats and the 2 Republicans, but the 3 Democrats can meet together, even though they constitute a quorum of the board. They can meet together and discuss whatever they want, wherever they want, without providing notice to the public, without opening those discussions to the public. They can't make decisions, they can't vote, but they can talk about whatever they want. And finally, the third exemption is any matter made confidential by federal or state law Examples of this might be a school board having a discussion relating to students, whereas that conversation is made confidential by the Family Educational Rights and Privacy Act, the federal confidentiality statute relating to student education records. That conversation might be exempt from the open meetings law. And a very, very common example that people get confused about sometimes is where a public body is having a meeting with its attorney, with its legal representation, where that conversation is covered by the attorney-client privilege. So perhaps you have a town board meeting with their town attorney for the sole purpose of requesting and receiving legal advice. The mere presence of an attorney is not going to be enough to trigger this exemption. The attorney has to be playing an active role providing legal advice. Once the attorney's active role stops and you go back to the decision-making process by the town board, the exemption ends. The exemption only applies to the portion of the gathering that where the attorney is playing an active role in providing legal advice. This can be part of an open meeting. For example, perhaps instead of saying we're going into executive session, a public body may say we're going behind closed doors right now to have an exempt portion of the meeting, to have a conversation with our attorney that is subject to the attorney-client privilege. Often I hear public bodies mistakenly say they're going into executive session to have a conversation that's covered by the attorney-client privilege. It's a technical error. They're still permitted to go behind closed doors. They're calling it executive session instead of exemption, which can cause confusion for the public. So it's just better if whoever is saying that they're going to go behind closed doors is clear and uses the correct language and state that it's an exemption, not an executive session. Further, the public body could just have a meeting with their attorney without letting the public know. They could schedule a conference call, they could schedule an in-person meeting with their attorney, and the public does not need to know, again, as long as the discussion is limited to a conversation that is covered by the attorney-client privilege. In terms of noncompliance and enforcement of the open meetings law, enforcement is through the initiation of a civil practice law and rules Article 78 proceeding. Any aggrieved party can bring a CPLR Article 78 proceeding against a public body if they believe the public body is not complying with the open meetings law. If the petitioner prevails, the court has the authority to award costs and attorney's fees. If that they find that an action was taken at a meeting held in violation of the open meetings law, or as a result of substantial deliberations that occurred at meetings held in violation of the open meetings law, the court could invalidate the action. But they're going to need to, the court will likely need to find that it was a substantial violation. Mere technical violations are usually not going to lead to an invalidation of an action. The court also, the open meetings law also states that a petitioner, if the petitioner prevails, the defendant public body could be required to take training from the Committee on Open Government. And just think, you guys are all doing it voluntarily without being ordered to do it by the courts. Questions. If always, anyone is welcome to contact our office by phone or by email with questions, anyone. Government employees, members of the public, media representatives. That's our telephone number. That's our generic email account. For people that logged on late, I'm just going to quickly go back and show everybody. Hold on, I need to open. Because I think as I was talking, out of the corner of my eye, I did notice a couple of people asking about the presentation. So again, very quickly, I'll ask that you not email me and ask me to send you a copy of the presentation, because if you scroll down on the Committee on Open Government's website and go to this link right here, click on this link, you will see within the next couple of days, you'll see a recording of this program here, and you can log on and find this a link to the PowerPoint that I just went over is right here. You can open it right there. So if anyone was asking about being able to obtain the training material or the information session material, it is right there. Okay, so the next thing I'm going to do is I'm going to stop that, and I want to go back to my chat feature and see if we have any questions that I can answer. There we go. I just need to scroll through. I think this one question indicated that I may have answered it later, so I think I don't need to answer that. Here's a question. We have an adversarial town government that refuses to follow the open meetings law whatsoever. If you want an agenda, notice to review minutes, you must request in person. They stop posting all minutes to include reorganization. They have in the past. What are the teeth in this law, and how can a town government be compelled to not violate the law? So I talked about that at the end. Enforcement is through an Article 78 proceeding. The Committee on Open Government does not have enforcement authority. We have no statutory authority to investigate complaints. We have no statutory authority to compel an agency or a public body to take action. Someone asked if the reason for executive session needs to be stated in the written agenda. That's a good question. Oddly enough, there's nothing in the open meetings law that requires that an agenda be prepared. The open meetings law is completely silent with regard to agendas. Not to say that many entities don't prepare agendas. That's fine. Certainly, they're more than welcome to and encouraged to do that so that the public knows what they plan to discuss at the meeting. But because there's no statutory obligation to prepare an agenda, there's no obligation to include the reason for going into executive session in the agenda. For example, the agenda may simply state that they're setting aside a time for going into executive session if needed, or they're setting aside a time to make a motion to go into executive session. Technically, you cannot schedule an executive session in advance from a very technical perspective, because in order to go into executive session, you need to make a motion to go into executive session. And theoretically, you don't know whether that motion is going to pass or not. It's going to be approved. So again, technically, theoretically, you cannot schedule an executive session in advance, but there's really nothing wrong with maybe on an agenda setting aside a time for when an executive session might be. Someone asked about whether we've given a formal opinion on what it means to later transcribe. No, ultimately there's no time limit in the statute for preparing a transcript. What it means, what we've been advised by the governor's office, is that the intent was that it's a word-for-word transcription. It's not the same as meeting minutes. It's a word-for-word transcription. Public bodies don't need to hire a court transcriptionist or court stenographer. If they're using a remote access platform that has a transcription program built into it, for example, I think Zoom and WebEx both have transcription options in their built in. Feel free to take advantage of that as a public body. Do whatever is the least expensive option and causes the least amount of work for your staff, because a transcription requirement can be onerous. So that is just our informal opinion on what it means to later transcribe. With it in terms of exemptions, the public can't speak, then who enforces the then? We've talked about, someone was asking a question about enforcement. Again, enforcement is through the open meeting, is through an Article 78 proceeding. Someone asked, can I comment on a caucus meeting consisting of a quorum or even an entirety of a public body, which caucus decides that certain items will be placed on a consent agenda with no indication whether any discussion or dispute occurred in caucus? Caucuses are exempt from the open meetings law. they can discuss whatever they want. If something requires a vote, votes cannot occur. Votes of a public body cannot occur in a caucus. But if there's some sort of consensus about what types of items they want to move forward, they're free to do that in caucus. Again, there's nothing in the open meetings law that relates to agendas. There's no process, there's no statutory process for establishing what gets placed on an agenda. That is often going to occur in sort of in a political fashion, I suppose. So if it requires a vote, no, votes cannot occur in executive session, but likely a decision to decide what to put on an agenda is not going to legally require a vote. So I think they can likely do that in political caucus, and yes, that would be closed to the public. There is a court decision that states that if you have a public body that consists entirely of a single political party, if you have all Democrats on a 5-member town board and all 5 of them are of a single political party, there is a court decision that states that they have to limit their political committee meeting discussions to political business, and any town business has to be discussed in an open session. Again, that's based not on statute, but based on a court decision. Someone asked if the agenda of a meeting is included in the documents that must be posted ahead of the meeting. What must be made available prior to meeting are records scheduled to be discussed. The word agenda has no legal meaning. It has no statutory meaning. It's never used in the open meetings law. So it just depends on whether it is a record scheduled to be discussed. Someone asks why there's been no OML push for public participation being required. I mean, that's, any change to the open meetings law requires an act of legislation. So if that's something that you're interested in seeing a change to the open meetings law, you need to contact your local legislators. Someone says it's not clear on when a board member has to allow the public to come to their house for a virtual meeting. If a meeting is being held in compliance with Chapter 1 of the Laws of 22, which is the law that currently allows for remote meetings, public bodies are not required to allow in-person physical attendance at the meeting. So that means that if you have members that are attending from their home, logging onto a WebEx or a Zoom or whatever the case may be, there's no obligation for those people to open their houses to the public. However, if you're having a meeting that is fully public, you're not offering a remote option. If a public body is not offering a remote option, they are having a fully in-person public meeting, then if a member of the public body wishes to video conference, they need to comply with the video conferencing requirements of the open meetings law, which requires that all locations be open to the public, the locations be included in the notice, and that the notice includes a statement that the public is welcome to attend. The way the open meetings law existed prior to pre-COVID, so to speak, the goal was not to allow people to attend from their homes. The goal was to make it easier for example, people that may be out of town during a meeting of a public body that they were a part of, or maybe such as the Committee on Open Government, where you have appointees from all over the state and you're trying to cut down on travel. The Committee on Open Government, we have people that have been appointed to the Committee on Open Government that live all over the state of New York. So we established a Buffalo site, an Albany site, and a New York City site to cut down on travel so that not everybody has to travel to New York City, or not everyone has to travel to Albany for these meetings. Or maybe, again, you have somebody who is on vacation out of town, traveling for work, traveling for pleasure, but they still want to participate. So you have those secondary locations. And if you're having those secondary locations, pre-COVID, all of those locations needed to be open to the public. There was never an intent for the under the Open Meetings Law for members of the public body to just, I don't feel like leaving my house tonight. And I feel like, you know, I'd rather sit at home in my pajamas and log on. That wasn't the goal. So yes, pre-COVID and ultimately at this point post the expiration of Chapter 1 of the Laws of 22, unless there's some other legislative change, if a member of a public body wants to attend via video conferencing, they will again need to open their location to the public. Someone asked if a meeting is being held as a hybrid, both in-person and remote options. Does a committee member have to advertise their home address and have it open to the public if they are attending remotely due to an illness? So if the public is being given opportunity to attend remotely, if the public body is complying with Chapter 1 of 22, that means that the public has the opportunity to attend remotely contemporaneously as the meeting is going on, and the meeting is recorded and later transcribed. Members of the public body that are attending from a secondary location do not need to open their homes to the public. Someone says, regarding the video recording, please advise that the recordings may be edited by the AV coordinator prior to posting to the website. Well, that depends on quite a few things. That's the only reference to recordings being posted to the website that's in the Open Meetings Law is if you are using the recording as a substitute for meeting minutes. If instead of posting meeting minutes within 2 weeks of the Open Meetings Law, you are posting a video recording, the law states that it has to be an unedited video recording. Otherwise, the law is silent. There's no obligation to post video recordings online. They need to be available upon request. And yes, of course, whatever is available upon request should be unedited. But if someone wants to post an edited version of a video recording for a proper purpose, like I've had situations where I've been told by the town, maybe a town clerk or somebody that, well, somebody got up and started yelling racial obscenities during the public portion session, and they didn't feel comfortable posting that portion of the meeting online. Well, that's probably a pretty good reason for editing the video before posting it online. So again, if you're posting if the public body is posting the recording in lieu of posting meeting minutes, then it has to be unedited. Otherwise, it's at the public body's discretion. What is the best way to handle a town board that refuses to allow public comment and refuses to openly deliberate resolutions and merely describes the resolution and then votes on them? Talk to them. That's, you know, just express your concerns in writing. Obviously, if they're not allowing for public comment, then express your concerns in writing to your representatives. And that's why we have elections. If you don't like the town board that you have, another couple of years there will be an election and you can elect new people to fill those positions. Someone asked how long transcripts have to be kept. That is not governed by the Open Meetings Law. That will be governed by the record retention schedules established by the New York State Archives. So if you need an answer to that question and you can't find it in your record retention schedule, the LGS-1 for municipalities, then I would contact somebody from the archives with that question. Someone asked, does an agenda listing for an executive session and its purpose replace the need for motion? No, it does not. Motions always need to be made going to go into executive session. Agendas are not going to be sufficient. Someone asked if there's a place where a citizen can access legal assistance when filing an Article 78 proceeding. That's not my area of expertise. You can contact maybe your local bar association or something of that nature, maybe the NYCLU, but that's not something that the Committee on Local Government can assist with. Concerning motions for executive session about pending litigation, in what way should the nature or focus of the litigation be disclosed to the public, especially when the municipality is involved in more than one lawsuit? I guess I don't understand the question. I think the best thing to do is identify, when making a motion to go into executive session, unless there's a really good reason not to, I think it would be sufficient just to identify the litigation that you plan to discuss or the public body plans to discuss. Like, for example, going into executive session to discuss litigation strategy relating to City of Albany v. Smith, whatever the case may be. I don't really think anything more than that's required. Are committee meetings for the purpose of bringing suggestions or information to the full board subject to the open meetings law? I did discuss this at some length, the difference between committees that are made up entirely of members of the larger public body and the difference between those and between advisory committees that are made up of a mix of board members and non-board members. So as I said, I did talk about that at some length at the beginning. If this person wants to follow up directly, they can if they missed it. Someone says, if you post meetings to YouTube live town meetings channel unabridged, would that mean you don't need minutes? I answered this as well, that posting unabridged recordings does not replace the need to prepare minutes. It just replaces the need to post meeting minutes within 2 weeks. So I think that is the end of the questions that I've gotten. Where do minutes have to be posted? The open meetings law states, the recent amendment to the open meetings law states that they should be posted on the website if the agency has a website. Otherwise, they need to be available in response to a FOIL request. All right, thank you very much. If anyone has any follow-up specific questions, I'm available via email, and you all have a great day. Thank you very much.